Thank you. And thank you for the opportunity to be here to discuss this very important measure. You're going to vote whether the body here believes that South Carolina should abolish its death penalty. I'm encouraging you to vote no based on several points. One is that the punishment is constitutional for murder. It's constitutional. I'll expand on that a little bit, but let's remember that. And its value is in a just and fair punishment for certain aggravated murders, and the resulting deterrence from that punishment that helps and protects all of society. And finally, I'm going to submit to you and discuss with you that the offered points in support of a yes vote become unsatisfying when you look at the details. Now, a debate's not a debate without fair representation of at least two opposing sides. And arguing tonight for the yes vote that you just heard was Professor John Bloom from Cornell Law School. Professor Bloom teaches various courses on criminal law and procedure, both trial technique and appellate practice. He's also the director of the death penalty and juvenile justice clinics. And notably, to his credit and Cornell's, the clinic for the death penalty expressly does not take a position on the death penalty, but seeks to review the individual cases on the merits. And all are welcome to participate in his clinic. It's very inclusive. Professor Bloom has represented many death sentence inmates in South Carolina. He's also represented individuals in the federal system. Notably, he began the Death Penalty Resource Center here in South Carolina to aid in the defense of death sentence inmates, which continues his work and is now known as Justice 360. With Professor Bloom is Reverend Hillary Taylor, a Methodist minister and presently the director of South Carolinians for Alternatives to the Death Penalty. That's an organization that has existed for some 40 years, and it is organized to mobilize support for abolishing the death penalty and includes participation in the legislative process. I've seen Reverend Taylor at the legislature every once in a while. And like Reverend Taylor and Dr. Hahn on our side, they're going to speak to the moral element in sentencing. And one would think perhaps that's a little incompatible when you're talking about a legal issue, but it's not with sentencing in capital proceedings. And that's because our Supreme Court has instructed that the sentencer in capital proceedings is to consider the individual defendant's moral culpability. So they are welcome, their input is welcome in this debate. Lastly, on the yes side is third-year law student Stephen Hicks. He's obviously made very good use of his time here, serving as associate editor-in-chief for the Law Review and having already secured a position in a Charlotte law firm. Mr. Hicks and Mr. Millar both have taken on a significant burden to be here today to wade into very divisive waters and make informed comments, which I think will be very good for this debate. I thank everybody here as well, too. Now, to the task at hand. The proposition: this body believes South Carolina should abolish its death penalty. Now, the question itself tells us a couple of things that are not up for debate at this particular point. One, the death sentence is constitutional for murder. We know that. The Supreme Court has ruled that it is constitutional. Interestingly enough, when the moratorium went into place in the 70s, they did not answer the question on the constitutionality of a death sentence. But in Gregg, they did address it. And they said, yes, even the text of our Constitution contemplates capital punishment. And the Eighth Amendment does not compel the states to choose a lesser punishment for murder. Our statute was also reviewed by our state Supreme Court in State v. Shaw. It mirrors the Georgia statute that the United States Supreme Court reviewed in Gregg. And of course, our state court found that it was constitutional, just like the Georgia statute. Interestingly enough, for our statute, we have that individual sentencing and fail-safes at each step so that you don't have any type of mandatory sentence. And I think that's important for people to know. Even if you go through capital proceedings and he's found guilty or she is found guilty, there is no automatic death penalty. In this state, you look specifically at the crime and the individual. You look at those facts of the case, and you look about you look into the defendant's character, some of what he's done, his growing up years, what he's been exposed to. This is a very detailed process. And I argue that's going to be one of those points I'll come back to again and again, and I wish that you would all kind of consider when we start this debate, or you debate among yourselves on how you want to vote. This is not automatic, and it's very detailed, and it is constitutional. Now, many debates about the penalty are abstract, and they have themes and points that are just overarchingly general. But I'm going to suggest to you that you cannot have a full and fair debate about the death penalty without considering what crimes have been found to warrant the death penalty. As one judge has written, the discussions, when you omit facts, are a bit like playing Hamlet without the ghost. You're reviewing the merits of capital punishment without revealing why the punishment is correct. Now, it's a harsh punishment. There's no doubt about that. And remember, we have, in large measure, in most cases, asked 12 people in our community to sit in judgment. Now, that's a very difficult thing for jurors to do, and they listen attentively. But sometimes that harsh punishment is warranted according to the sentencer. Now, the harsh punishment that a just society can impose is what? The harshest punishment a just society can impose is death. And that phrase comes from the Fourth Circuit Court of Appeals in affirming the direct appeal in Dillon Roof. And unfortunately, regrettably, we know those horrible facts. They played for a long time in our state and in media coverage. And it is heartbreaking. I don't think anybody would disagree with that. At a Bible study at Mother Emanuel Church, the congregation members welcomed Dillon Roof into their Bible study. Then he slaughtered them. The Court of Appeals underscored that they reached the decision to affirm not as a product of emotion, but through an analytical process. And the reason I wanted to underscore that is that, yes, the facts are hard to listen to. They're hard to consider. And sometimes people cannot understand how these crimes could even occur at all. They are so horrific. But the process of sentencing is analytical. The process of review is analytical. So the punishment, most harsh, can fit the crime. And our state has witnessed some horrific crimes. And I will say that Professor Bloom was absolutely right. I am going to look at some of these so it gives us context. It will give us context to the question that I'm going to pose to you in just a few minutes. Consider 5 small children killed by their father, ages 8, 7, 6, 2, even 1 year old. The 2 youngest being so small, the defendant had to become a little creative and get a belt to wrap around their necks and choke them because his hands were too big to fit around tiny necks. Consider a man murdered in his home, his eyes burned, his family taunted by the killer, and the killer writing a message on the family wall, partly in blood. And by the way, that defendant had murdered before he got there, and he murdered somebody after. Consider a security guard shot and set on fire, his attempt to flee, as the court described it, bleeding from the neck and engulfed in flames, captured on video. The torture of a man over multiple hours while a defendant called his girlfriend and described the sodomy and the burning of the man, a man so horribly abused that he died from the sum total of his wounds, over 200. Now, here's the question I want to pose. Do we abolish the death penalty statute and reduce the maximum punishment under the law, a constitutional punishment, no matter what the crime? I'm not suggesting mandatory death penalty. I'm not suggesting that we use it more. I think it should be very selective. In our state, it has been very selective. But certain cases warrant the death penalty. Now, we've heard some arguments about a life sentence is good enough to keep society protected. I submit to you under our statute, that could be the case. And a jury, having heard all of the facts and considered everything about the crime and the defendant that is presented to them, may determine life, may determine death. It's up to them. If they find an aggravating circumstance. Again, we narrow discretion in the state. First, you have to find that the state has proven one statutory aggravating circumstance beyond a reasonable doubt before you even consider death or life. But if life sentence is good enough, leave it to the sentencer to determine. Now, deterrence. And I will agree with Professor Bloom that it's notoriously hard to create a way to measure this, because what you're measuring is what doesn't happen. That's very difficult. And people have studied this. They've used different metrics and ways of looking at it. But one study discussed in 2005 found that an execution on average, and this is a national average, saves 18 people from a violent death. One execution to save 18 people. Now, other studies said 14. Others, even still, will say 5. But another part of that is of interest to this particular audience, I believe, is that murder rates increase when the death sentence is taken away. Sometimes that's estimated as much as 5 more people. I think one way to evaluate, and with a very good metric, is the murder rates before the moratorium, after the moratorium. And that's what one study did. And they found after suspending the death penalty in the 70s, 91% of states faced an increase in homicide. 67% of those states found a decrease when the punishment was reinstated. And another study says the deterrent effect rises when executions go forward, but not when the sentence is imposed and the execution is delayed. I suggest to this body that is not a reason to abolish the death penalty. It is a reason to abolish delay in the death penalty. The potential to save innocent victims from horribly violent deaths, though, is here. The numbers do support it, and that is a very good reason to keep the penalty. But if you consider the statistics too variable, then there are also admissions. The late Senator Feinstein, in a parole board matter, once asked why there were no bullets in the gun for a criminal that went into, I believe it was a gas station. The criminal said, I didn't want to accidentally shoot somebody because California has the death penalty. There are admissions, and then it's just logic. If you have somebody serving a life without parole sentence in the Department of Correction, where's the deterrence for anything? It's there. Now, there's also concern about it being arbitrary and discriminatory. In 2005, the Department of Justice, after extensive study, found African Americans less likely to receive a death sentence than whites. Those were the numbers in the study. Even by the mid-'80s, when there was a difference with considering the numbers of race of the victim effect compared to race of the defendant effect, the race of the victim effect appeared to decrease greatly when you added more variables. In other words, when you looked at the case individually. I do want to ask you to consider that when other people consider whether to retain that death penalty, you might have a disconnect between the legislature and the people who actually vote. And 2016 is a very good model to look at. The Nebraska public voted to reinstate the death penalty after the legislature abolished it. The Oklahoma public voted to constitutionally protect capital punishment. This is all in 2016. And California voted to reject a repeal of the death penalty, but to reduce delay. All of this points to keep a death penalty system that is individualized, that is considered, and still has that ultimate harshest penalty for a very few cases where the defendant has earned that particular sentence. Thank you very much. I encourage you to vote no.